Hello and welcome to today's webinar, Electronic Signatures. Thank you for taking time out of your day and joining us this morning. My name is Cindy and I will be the co-host. Our presenter for today is George Finley. Thank you very much and over to George.
Thanks, Cindy. Thanks for the introduction. Good morning, everyone, from an icy Johannesburg. I don't know where you all are. That's the modern technology of today. But it certainly is bitterly cold here. And if you are here, you're probably sharing that with me. First and foremost, thank you for the privilege of your time. And thank you for showing an interest in electronic signatures and this introductory talk. So let's kick off. So LexisNexis, which is the company that I work for, has a strapline called Advancing the Rule of Law. And it's a proud banner that we carry globally. And around the world, it's a concept that unifies our company across the globe and is passionately supported by the people of LexisNexis. Our efforts include supporting corporate citizenship initiatives that strengthen civil society and the rule of law across the globe. But let's get down to what we're here to chat about today. And that is really the agenda. Let's have a look. We're going to look at the history of signatures. We'll talk a little bit about that. Something we're all familiar with and I'm certainly passionate about. We'll look at signatures today, why, of course, electronic signatures, and then we're going to look at the legislative environment, the signature facilitation, compiling the evidence, and then the uses in COVID-19, and then a Q&A at the end. But anyway, let's first ask ourselves, why do we sign things? I always ask that question, why do we sign things? And there's one word that comes up for me, and that's the golden thread word that's going for me that carries through this talk and through the concept of signing and the concept of electronic signatures. And that's the word certainty. Certainty for me embodies the whole principle behind it, because what it does is it gives you the feeling of confidence that something is true, based on reliable information. That is the certainty behind signing. That is why we sign things. And historically, if we had to ask ourselves, why is this really relevant? Well, if you think of it, back in the day, whether it was the Sumerians using cuneiform at the time to document what was happening in their lives, or hieroglyphics even, or if you look at Roman times, where you had Julius Caesar, for instance, Julius Caesar, or one of the Caesars, who would wear a seal ring on his pinky, which would be emblazoned with the crest of the Roman Empire at the time, whether it be SPQR or whatever the case might be. And what would he do? That seal ring or signet ring identifies him and gives him a certain identity. And what does he do with that? Well, of course, he dips that ring into the molten wax and then affixes it to a document. So we all see that in the form of a notarial seal. They don't do it that much anymore, but a beautiful notarial seal. What is that? It is the form of identification. And what it also does is it signifies the intention to do something. And then what it does is it records the event. So you've got three primary sort of cornerstones back in Roman times already, and that's the identification of the individual, the intention to do something. Argument's sake, he's just conquered Gaul, and now he's recording that in the document. So he's got the intention to record it, and then you have the recordal of the event, which is the document, which is affixed by his beautiful seal. And over time, that of course has changed. So only Julius Caesar, argument's sake, had this beautiful seal ring, but over time it has changed in the form of, let's say, quills and ink. Now you have the Pope or the aristocracy that would be writing on beautiful parchment paper with quill and ink, and they would also, in the same, but the intention remains the same, is to create the form of certainty based on the three things. One is the identification of an individual, the intention to do something, and a recordal of the event. Those are those three things. And that's, as I said, that certainty and those three things is the golden thread for me that runs through the whole principle behind all of this. And of course, from the quills and ink, we had Gutenberg's printing press with a proliferation of printing works, made paper and pens and the documentation accessible really to the man in the street, which of course brought it right down to, well, here's a lovely image of a glorious fountain pen, but of course ballpoint pens and the everydayness of it has become commonplace. So when it moves from the pen onwards, where does it go? Because the certainty must still be there. So if you think of it, the only thing that is certain after all is change. You know, we've moved from letters to email, and if you cast your mind back, the older ones in the room, whoever you may be and wherever you may be, the reluctance to move over to email and thinking that it was this sort of unique piece of tech. But now email is commonplace. The old art of letter writing has completely disappeared. And then we moved from cash to card. I mean, the whole thought of moving from a cashless society, at least from a cash to a cashless society, was a foreign concept. Yet today, it is actually very much part of our lives. Then we had the concept of the old landline telephone, and now we have VoIP or voice over internet protocols. We've got mobile telephones. So all these changes, you've got these changes from all these things. And I think this very thing that we're doing right at this very moment is the change from the boardroom to Zoom. Here I am sitting in Johannesburg speaking to all of you, and I've got no idea where you are, but we're all connected in real time. And so handwritten or wet ink signatures have also moved into the electronic age. And that is where we are. And that is what we're talking about today, is electronic signatures. So I spoke about certainty, and I spoke about those three things, which is the identification and the recordal of the event and the intent. So that's really important because the fundamentals of signatures remain exactly the same. The certainty fundamentals is what I call them. There's actually no real modern day set of fundamentals. Bear in mind, however, that people can and will always commit fraud. And bear in mind also, however, that people will go back on their word, and also that they won't carry out your wishes or their own intentions necessarily. So no matter what you do from a technology point of view, those inherent human traits will always be with us, sadly as it is. But what we can do is we can reduce those as much as possible by entrenching this new technology. So what are the four kinds of certainty fundamentals that we sit with? Well, they are identity, non-repudiation. So what does non-repudiation refer to in this context? It means the non-changing of the document, the unalterableness, if there is such a word, of the document. So that's the non-repudiation. We're talking about proof, and we're talking about confidence. So let's have a look at those. So if electronic signatures are so far better at achieving this than the aforementioned, so we're saying that electronic signatures are better at achieving these certainty fundamentals than any of the previous. That was the Romans or the fountain pen or the quill and ink. So what the electronic process does is it makes these things better. And how does it do that? Well, how are they better? So electronic signatures are a legal alternative under South African law. And we also have advanced electronic signatures, but we'll look a little bit more at those a little bit later. But let's start off at the top one there, which is the identity. So how do you know someone is who they claim to be? So that's the most common asked question. On the digital signature platform that we have, and we do distributed signing sessions and send documents out, the most common question I get asked is, how do we know that the person on the other side who's signing the document is who they are? Well, if you ask yourself with wet ink signatures, how do you identify someone? So with a wet ink signature, if years down the track, you think of wills that are in dispute, for instance, you get a handwriting expert, and that handwriting expert must then come and analyze the signature, how hard the I was dotted, and the light ups and the dark downs, and all the like. And that is what used to be done. But now, with the electronic space, we've got a different way that you can do handwritten authentication. So, for instance, all of you probably have seen these digital signing pads. We call them a Wacom pad, but a Wacom pad is really just the manufacturer of the pad. But we see them in a SARS office, or you might see them at Edgar's or at the post office, and we use them on our platform as well. And those of you that might sign mortgage bond documents on behalf of financial institutions that are using the digital signing process on a Wacom pad, will see that when your client signs on that Wacom pad, what happens is the details of that signing is recorded. It's known as the orthography of the mark. And that is recorded in the software of that signing pad. So again, the idea of having to get a handwriting expert is really no longer needed, because, as I said, the orthography of the mark is embedded in the software. So the other thing that you can do, a way of confirming the identity, is electronic authentication. So how would you do that? So as an example, if I had to send a document out for someone to sign, how will I authenticate them electronically? Well, you've got a few things. Well, one, they need access to a system. So the system, be it all of you that are listening to me now, accessed your computer. How did you access your computer? Well, probably Control-Alt-Delete, and then you put in a password that only you knew. And that was one form of authentication already. If I had to have sent you a document to open, I might ask you to open that by entering your identity number, or maybe a one-time PIN. I often use the example, and for me it's a classic one, of coming back to those initial fundamentals of identity, intention, and recordal. So if you ask yourself, if you go and draw 100 Rand at the ATM, and you stand in front of the ATM, what do you need? Well, one, you need a card. So you need an item with which to identify yourself. Then you insert the card into the machine, and it asks you for the one-time PIN, which is only something that you know. You enter the one-time PIN, you draw the 100 Rand, so that was your intention, to draw the 100 Rand. And where is the recordal of the event? Well, it's on the little slip or on your bank statement. It says at a specific time, date, and place, you, one, identified yourself by putting in the PIN, and two, you had the intention of withdrawing 100 Rand, and three, the event is recorded. So that is an electronic way of identifying a person and then recording that event. Furthermore, there are other ways of identification, and that could be biometric authentication. We've seen that in the form of modern day iris scans, maybe at airports and the like, and of course the thumbprint biometric authentication. So in any electronic signature platform, that could be a form of identification that can be used as well. A fourth one, also in the identity fundamentals, is cryptographic authentication. That is the form of private and public key infrastructures. And those of you that work with digital guarantees, for instance, in the mortgage bond space, will be familiar with this cryptographic authentication. For instance, those guarantees are issued, and the person issuing that has to be in possession of a digital certificate which has properly identified them so that they can sign that document. Right, so let's look at the next one, which is the non-repudiation. And that was what I would just call no tampering. So the important part about these electronic signatures and the electronic documents is you can lock the document down. If you've locked the document down, nobody can tamper with it. So that is one of the certainty fundamentals that is absolutely crucial. So not only do you have proper identification, but you have non-repudiation of the document, and similar to my withdrawing of the money scenario, you have a recordal of every step of the signing session. So what happens with the electronic signature platforms is the person is properly identified, and then the whole signature process, the time, date, and place of signing is properly recorded. And that, of course, gives you the proof, and the proof is in the form of an audit trail. So any proper digital signature platform will keep an audit trail of everything that has happened, when the person signed, how they were identified, and the time, date, and place of signing. And when you've done all of this, it obviously gives you the confidence that your document will, at the end, stand up in court, that your signatures will stand up against any form of scrutiny. So these are the certainty fundamentals that I talk about. Okay, I'm going to move on to have a little bit of a look at the laws. Let's look at the laws, because the question is, and I think in that opening, I don't know if any of you saw that the little video clip that I made prior to this webinar, and it started off with how do you do, and then it asked a whole lot of questions about how do you, and one of the key questions was, how do you know that your document will stand up in court, and how do you know that your document is compliant? Well, you've got to look at the laws. So let's have a look what is applicable. We've got three sets really, in essence. The one is the common law, the second one is the ECT Act, and the third one is legislation applicable to a specific transaction. So I want to stand still just a little bit with the common law. There is an enormous amount, I think the proper word is a plethora, of case law with respect to signatures. And the whole question of the making of a mark and the definition of signatures in the common law goes back into the previous century. The legal practitioners among you will also remember in the law of evidence, it's one of those beautiful scenarios that it's also deemed to be proper identification and a signature where the witness symbolically touches the pen of the magistrate who then makes a mark on the document. You will recall that from your law of evidence classes. I can just imagine that scenario, but that to me is a lovely picture. But that's the common law applies. And of course, the ECT Act, so that is the Electronic Communications and Transactions Act, promulgated in 2002, I think it was early in August, which is quite a long time ago. But the ECT Act confirms the common law. And the ECT Act, importantly, is also technology neutral. So that is the law that you've got to look at when you're using an electronic signature platform. And bear that in mind, if you're in the jurisdictions of South Africa, ask yourself which platform you're using and ask yourself if it is ECT compliant. Very, very important. And then the third line that I have there is the legislation applicable to a specific transaction. I'm going to touch on that a little bit later, but also very important when you're looking at any document or contract or whatever it might be, which legislation is applicable to that document, and you've got to read all of them together, the common law, the ECT Act, and the legislation applicable to a specific transaction. You can't read them separate from one another. Okay, so let's look at what the ECT Act says. The ECT Act says that basically the signatures of today in terms of the ECT Act, well, it talks about consent, and that is where a party agrees without necessarily signing. The ECT Act says that consent is valid in electronic form if the person's intent can be inferred. So that's pretty straightforward. That's the handshake, or if you're just signing anything at the bottom of your email. And the same can be said for electronic signatures in terms of the ECT Act. It's a very, very wide definition. In essence, according to the Act, anything that you intend to use as a signature, it says, is a signature. This means that a checkbox, your name at the bottom of an email, digital signature, etc., are all forms of electronic signature. You think, for instance, things like, I think they call it a click wrap agreement. So whenever you are doing something online and there's a little box with a little tick box that you click and accept, so in that click wrap agreement, that is your form of electronic signature. So a very, very broad definition that's given here by the ECT Act. Thirdly, we've got the concept, and this is what I mentioned a bit earlier, of an advanced electronic signature. Now, they aren't advanced for any technical reason, but they are advanced in the sense that there are digital signatures that are made with a digital certificate which identifies the specific person. So there's quite a rigorous process. That person needs to be identified properly, and then that digital signature gets issued to them by an entity that is approved by the Department of Communications. So in this case, we only have two in South Africa at the moment. The one is the South African Post Office, and the other one is a company called Law Trust, which is 20 minutes drive from where I'm sitting at the moment. And they are authorized to issue the advanced electronic signatures. And what are they able to be used for? Well, again, in the previous slide, I said, look at the legislation. So what it says there is that if a piece of legislation requires a signature, then only an advanced electronic signature will suffice. So if you're thinking of signing a prep clause for your title deed or for your power of attorney, then only an advanced electronic signature will suffice. If you read this together with, argument's sake, the Commissioner of Oaths Act or the Justices of the Peace Act, only an advanced electronic signature will suffice. We at LexisNexis, for instance, we resell advanced electronic signatures from both those organizations. Those of you who do transfers, for instance, and are familiar with the electronic rates certificates that get issued, those get signed by way of an advanced electronic signature by the relevant municipality, and those are ones that we issue. Challenges that lie ahead of us, of course, are the testing of these advanced electronic signatures by the courts, and, or shall I say, even just the acceptability of it. So the challenge is out there to all of you to be the first ones to sign affidavits using advanced electronic signatures. My interpretation, just mine, is that there's nothing legally prohibitive in doing that. The question is that whether they will be accepted by the courts. But those are nice challenges that we have. Importantly, in the ECT Act, there's a schedule. If my memory serves me, it's Schedule 2, and Schedule 2 refers to certain bits of legislation that are excluded from the ECT Act, where wet signatures are always allowed. Pardon me, where wet signatures are compulsory. Classic examples of these: the Alienation of Land Act, bills of exchange, and wills. And funny enough, in my interpretation, I think the document that should be signed by way of an electronic signature should be a will. Can you imagine how perfect the world would be if the testator or testatrix is properly identified, 1. 2, if the intention is there, and 3, if the recordal of the event, time, date, and place of signing is properly recorded. If only that could be applicable to wills, I'm sure all those family disputes and all that litigation revolving wills should be diminished greatly. Similarly, the question of deeds of sale for fixed property and those long-term leases, but more importantly, the deeds of sale. Those of you in the virtual room that we're in, that are in the property industry, maybe the estate agents or the real estate people, the temptation is great to sign a deed of sale using an electronic signature platform. The logic is perfect because your identification, your recordal, etc. is all there, but you may not. It's prohibited. So it's excluded from the workings of the ECT Act. And that's a very crucial thing that one must remember. There's some other bits as well, of course, and that is the suretyships and a variety of other pieces of legislation. But let's have a look at some other acts in the legislative environment. So we have in our research looked at various pieces of legislation. Here is a list of 10, and in our interpretation, Lexis, a digital signature platform, can be used for documents regulated by these acts. So we're comfortable with that, but of course you've got to read and research every single one of them properly. So importantly, however, and this I cannot emphasize strongly enough, is have a look at the exclusions. I've mentioned now the Alienation of Land Act, I've mentioned wills. Look at the credit agreements. All of you know, when you sign those mortgage loans, they need to be signed in the presence. And if they're not signed in the presence of the other party, in this case probably an attorney, they need to be signed by an advanced electronic signature. So bear that in mind. Suretyships, you've got that piece of legislation that I think it's the General Law Amendment Act, which also requires a signature. So a suretyship would need to be signed by way of an advanced electronic signature. So it's very important that you bear all of those in mind too. So usually at this stage, what I do is I do a demonstration. I do a live demonstration, but in a room with as many people in it as there currently are. The practicality of that is not really doable, but I'm going to do this by way of an illustration, really. So, and that is what I call just why electronic signatures, and there's only one answer to it, and that is because of the ease. I want to sketch an example or a scenario. Here I am, I'm George, I'm sitting in Johannesburg. There you all are, and I don't know who you all are or where you are, but let's hypothetically say you're all directors of a company. I'm the company secretary, you're all directors of the company, and you all need to sign a resolution. So what I'm going to do, I use a digital signing platform. In my case, I'm using Lexis Sign, which is the LexisNexis platform. And I draft a one-pager resolution, and I need to send it to all of you. And what I can do now is I've drafted, you're all sitting at your computers, wherever you are, you're all sitting at your computers, and I send it out. And really what it does immediately, it says, I don't have to wait for the document to be returned. I will have the document back on my desk instantaneously the moment you sign it. So all of you will receive an email as we speak. In the email will be a link. You will click that link, it'll open the document, and the moment you sign it, I will receive it. And the benefits of that are really massive. Well, so I don't have to, as I said, I don't have to wait for the document to be returned. Furthermore, your service as a practitioner or whatever the nature of your business is far, far better than it used to be. You aren't wasting any time. There are no couriers. There's no postage. And I have this little rhyme that I always say. And they're 4 things: print, sign, scan, and email. So that's what we're all kind of used to, is you send off a document, someone on the other side prints it, signs it, scans it, and emails. But by doing those 4 things, you fall into every single trap of the certainty. 1, you don't identify the person properly. You don't authenticate him in any way whatsoever, that is. And the document gets printed, so all your legibility goes up the creek. So you have all these problems. Whereas now, you don't waste any time and you've got no additional cost. I mentioned earlier, one of the fundamentals is the non-repudiation, which is the non-altering of the document. If I send this resolution out to all of you sign the document and I get it back, what I know is that the document has not been altered. None of you can print it, make a change, scan it, and then email it back to me. It's a major benefit. Well, the sign anywhere, anytime, it's a little bit like a Zoom meeting, is that you can have a board meeting anywhere, anytime. which is basically what we're doing now. Fifthly, well, it's the customer experience. You can imagine if all of you, as I said, were members of my board or trustees of my trust, the experience that you can sign anything, anywhere, anytime, on any device is a major benefit. Preventing fraud, well, obviously, I said earlier, you can never prevent fraud entirely. People will always go back on their word and their intentions might always change. But if you can ensure that a document remains tamper-proof, that is where a major, major benefit lies. So that's really why you use electronic signatures, is for all these are the sort of the salient features of using electronic signatures. But let's just look, if I send this document out to you, we have discussed this in briefly, but if I send this document out to you, how am I going to facilitate the signature? So let's say there is my colleague who's sitting in George, argument's sake. How am I going to identify him? So I send the document. Well, one, that person has to be at a computer, and they need to have access to that computer in which they're going to receive an email. Then they need to log into that system. They need to capture an identity number. That would be my first port of call, is that they need to put in an ID number in order to access the document. Or I can add what is known as multi-factor authentication. And we're all familiar with multi-factor authentication. If you ask yourself, if you're doing EFT, electronic funds transfer, you have multi-factor authentication in the form of one-time PINs that are sent to you that you've got to insert before the transaction takes place. The same when you're making a credit card payment, they send you a one-time PIN. What does the one-time PIN do? Well, you have to have your cell phone with you, you have to have access to your cell phone, you have to be able to read the SMS with a one-time PIN, which you then insert on the platform. This works in exactly the same way. As part of my identification process, I ask you to insert the one-time PIN so that I can be sure that it is you. Right, so secondly, the visible representation of intent, so that's recorded in the audit trail. I mentioned earlier about the Wacom pad, recording the orthography of the mark, so that's the one thing. But what the electronic signature platforms do, or ours certainly does, is when you sign the document, this resolution that I've sent out to all of you, behind your signature is a watermark. And this watermark records the time, date, and place of signing. And that is an absolutely crucial part of the recordal of the event. Right, so last line on this one is the question of the recording of the, or the keeping of the document. The platform, as in our platform, stores the document for you, but of course you can store that PDF document wherever, in whichever storage system you have on your system. And the key thing is that you have proof that that document is unaltered and it has the watermarks behind each and every signature. And what does this give you? So this comes back to my key word that I used right in the beginning, and that is the word certainty. Why do you want the certainty? You know, we all sign wills and contracts and things, and we never ever look at them until things go wrong. So that is the key part, is if you're using an electronic signature platform, where does the certainty lie for when things go wrong? And the ECT Act makes specific provision for that. I think, if my memory serves me, it's section 15, which deals with what we refer to as the evidentiary weight. So what is the evidentiary weight of the work that you've done? So if you, for instance, are just emailing or SMSing, yes, the contractual validity is there, but is the evidentiary weight there? That is why you must use a proper electronic signature platform, because that compiles the evidence. So it keeps a record of the evidence for when you need it one day. So that's what I call or refer to as compiling the evidence. So firstly, you have the reliability in document generation, document integrity, and identification of the originator. So you've got a certificate identifying the platform, and let's say in our case, it's the LexisSign platform, which is sealed with a digital signature. So that's point one of your evidentiary weight. You have reliability in the document viewing. So that was how you, as the signer of my resolution, viewed the document in the original PDF format. And of course, that PDF document is unalterable because it too is sealed with a digital certificate. And then you have the reliability in storage of the document. So you have the digital signature integrity, and it can be stored in a records management storage of your choice. But the important part is you've got the long-term verification sealed by the digital signature of, in our case, it would be Law Trust. So very, very importantly for me is to be able to say to you in conclusion that electronic signatures are a legal alternative to handwritten signatures in our law. Secondly, they are more secure and reliable than pen and ink. The purpose is the same, but the fundamentals are entrenched and are far better than the pen and ink versions that we're traditionally used to. And of course, in today's world, they are now more relevant than ever. So one of the things that's just like Zoom has catapulted us all, that I mentioned earlier, into this virtual world of meetings by way of computer, so to this COVID-19 situation that we're all in has catapulted the relevance of electronic signatures into all of our worlds. Just to give you an example, for instance, in the last few months, for instance, we have had a list of needs, call it needs and uses for electronic signatures purely in the COVID-19 kind of space. Visitor evaluation forms, permits for essential workers, applications for restructuring debts. A classic example, the financial institutions that are sending out documents for the restructuring of debts, but they don't, people don't want to go to the branches, people don't want to go to attorneys, or people are, the firms are still shut. They can do all of these by using electronic signatures. And the fundamentals of obtaining certainty are not just intact, they are better than a handwritten scenario. So these is just a list of examples that we've used literally in the last few months using electronic signatures in the COVID-19 drama space that we're all living in. So to close off before we can lead to questions and so on, I just want to say to you, this is the landing page of LexisSign, which is the electronic signature platform of LexisNexis, www.lexissign.co.za. It takes you to that page. On that page are the processes of how to facilitate the signature, how to sign the document, how to read the audit trail of a signing process, and how to store the document. That is all there, and you are most welcome as well to try them out. Thank you very much for your time, and as I said right in the beginning, thanks for the privilege of your time. All the best.